and obfuscated with what happens. But if you look at exactly what occurred, it comes down to a very simple mistake made by Hugh Buie in 2001. Hugh Buie Sr. was developing a piece of property into a homeowners association, and he created lots, and then he created common roads and a common area to benefit as a recreational area. There was a portion of the whole property to the south and the east that was not included in the homeowners association. He created the association, and then he issued a warranty deed, and the warranty deed was to deed the common areas and the common roads to the association. Then in that warranty deed, which is at page 3239 in the record, he reserved a non-exclusive perpetual easement for ingress and egress on and across the property in Exhibit B, and then reserving also the right to grant or convey that easement or any portion to any third party. The problem with what Mr. Buie did back then was he reserved that easement to himself over the common roads, but not over the common area. And the common area is what he intended to be a recreational area, not only for the Property Owners Association, but for the southern parcel, excuse me. Then 2 years later, he tried to correct that mistake by issuing the Common Area Amendment, which is called the Developers Amendment or the Common Area Amendment. And it was recorded June 6, 2003. The problem is, at that point, the issue becomes, did he have the authority as developer to do that, or had it become a director, owner-controlled association? And that's the whole big argument here. The trial court found...
So just to put a fine point on it, it seems to me if the trial court was correct that turnover occurred in January of 2003, then it would be undisputed that the developer's amendment that he did would not be valid. Is that correct?
Well, it would not be valid according to the way it was supposed to be done once the owners were in control. But then my fallback position on that is, however, by subsequent actions and conduct, the association waived strict compliance. And I lay that out more fully in the reply brief as to implied waiver. And that is, if the developer's amendment was recorded in June of 2003, there was never any attempt to make any change or any complaint about that for at least 4 years and maybe close to 5 until the lawyers got in and this lawsuit got filed. And that's the first time there was a complaint about it, number one.
I thought the lawsuit was filed in 06. Is that not correct?
Oh, I'm sorry, then. I thought it was 07.
Maybe, well, let me ask you this.
At least
there was no statute limitation. It was within the statute of limitations, wasn't it?
Yes.
So why would the waiver and estoppel and latches, why would that matter?
Well, it matters because Mr. Buie recorded that amendment so that when he sold the other parcels, the other lots in the lower parcel, that he would be able to give them access by roads and to the common areas to those things he had deeded over. And so when he attempted to fix the mistake by the Common Area Amendment, he then went ahead. I think the Common Area Amendment was 2003. I want to say it was late 2004, early 2005, or maybe 2005 into 2006, that he began to deed out the other lots in reliance on his belief that that amendment was valid to give him the right to deed out the common use of the common area.
What you said, isn't that the fatal problem with the waiver and latches and all that? In reliance upon what he did, latches and waiver and estoppel, you would have to rely upon something the association did to your detriment. And that's what I'm not seeing, other than them waiting to file a lawsuit within the statute of limitations. I guess I'm struggling to understand.
Well, they failed to object. They failed to take any action. Well, let me give you another fact. The amendment was recorded in June of 2003. No one objected at all. We contend the turnover occurred either late that year or early the next year when Mr. Buie filed a relinquishment of control in the public records of Columbia County. And at that point, then after that, at some point, Mr. Buie tried another amendment. And this time, the association got all up in arms and said, you can't do that anymore. You've turned over control. And he withdrew the amendment. Now, no one did that before to the common area amendment. They only did it after the turnover in 2004. And I would contend that that is further indicia of the fact that none of these parties thought turnover had occurred until 2004.
And it sounds like there was disputed evidence on that point, but the trial court resolved that dispute in a way that found that turnover did occur. So we can't, I mean, there was competent substantial evidence to support that finding, was there not?
I don't believe there was, because number one, the turnover occurs under the statute, under chapter, under 720, when it's a turnover when the majority elects directors, not officers. In January, they elected officers. They did not elect directors. By the plain language of the statute, that's insufficient to create turnover. In fact, what was filed with the state of Florida for 2003 showed the only directors were the Buies, and this was filed 11 days after the meeting where they supposedly turned over, and only the Buies were directors. The next year with the state of Florida, this was in 2004, and I believe it was filed shortly before, it's all in the record, shortly before he filed the relinquishment of control. The document filed with the Secretary of State shows the Buies as still 3 directors. It does not show the Buies as being removed. Then it shows 4 officers on the other side, and it doesn't show that those 4 officers are also denominated directors, except that they have words after their name, each of their 4 names saying DIR. So all we know is sometime by 2004, they were at least, it was signed by also one of the association members, which is further indicia of turnover had occurred after.
But are you asking us to reweigh what Judge Slaughter already weighed? Because there was testimony, I think, in the record where the individuals who were present said that they elected directors. And so Judge Slaughter obviously accepted their testimony over whatever the state of Florida has in their Sunbiz records to show who the directors were. Are you asking us to reweigh that testimony, and is it appropriate for us to do that and weigh that evidence?
I would suggest that the parties use the words directors and officer fast and loose.
But you probably argued that to Judge Slaughter in your closing, and he chose to believe that they elected directors.
And we just argued that the statute itself requires the directors to be selected, and there was no substantial competent evidence that directors had been selected at that time. But that's...
Was there association work going on? There were assessments, there were things that happened that would require directors, presumably, to vote on. And in this case, I believe the record also said Mr. Buie was present in all of these meetings, but none of the wife and the son, who were the ones you allege were the directors, were never present. So how would any work get done if there were no directors present?
There's no requirement that the directors be the ones that do the work necessarily.
The assessments?
It's the election of directors is triggered by the turnover. Doing the work can be done by an officer or someone that calls himself, but to the state of Florida, they were not directors until 2004. And we would suggest there was no substantial competent evidence. But then I would suggest also to you that even if there was a mistake made, and he should not have done that objection at the time, there were 5 amendments done at the same time that were recorded in June of 2003. 3 weeks later, Mr. Buie's attorney came to the meeting and explained to everybody that once there's turnover, here's how you do amendments. They had knowledge of how amendments should be done. It had not been done in any of the 5, and no one went back to change any of those 5. They remained the same, and no one complained.
Those haven't been challenged in this case, so
no, they were never challenged at all. But what I'm saying is none of the 5 were challenged at all, which suggests to me that knowing that that was the process they had to go through after turnover, that they were accepting there had been no turnover either. In fact, I believe one of the evidence that was...
Are you saying that knowing how to do something and not doing it is the relinquishment of a known right? By the inaction is affirmatively showing intent to relinquish a known right?
No, I'm suggesting, what I was going to say is at least even the treasurer or the president at the time, Jack Smith, testified in his deposition that was shown at trial at transcript page 56, he acknowledged that turnover had occurred in 2004. So this was an acknowledgement in the record. He was questioned about that. I asked him at that place when it did occur, or someone asked him, he said 2004.
Counsel, let me interrupt you for a sec. I think you had said you wanted to reserve about half your time.
Yes.
I think you're down to about 5 minutes left, so it's
Okay, I
more than
wasn't
half.
sure. Okay, then thank you. I will come back.
Thank you.
Good afternoon, Your Honors. Guy Norris on behalf of the Bluebird Landing Owners Association, and of course we also have Counsel for Old Republic, the other appellee in the case. If it pleases the court, we seek to split our time evenly as best we can under the circumstance. So if it may please the court. So, Your Honor, we have very extensive findings of fact and conclusions of law by Judge Slaughter, who heard this case. The appellee has, appellants are appearing before you now and seeking to re-argue many of the facts. We think that these are clearly supported by the competent substantial evidence and should not be disturbed on appeal. There's no prejudicial error, and that these findings and conclusions are correct.
Can you clarify
They should be
one?
affirmed.
Can you clarify
Yes,
a fact or two for me?
Yes, Your Honor.
This case has nothing to do with ingress, egress on the roads. Is that right?
Really doesn't.
So the second thing-
Except to the extent that the preserve owners, prior to them being exited from the case after the case with them was settled and an agreement was reached with the association for the maintenance expenses of that, and except for the common area and the maintenance and upkeep of the common area and the use of that, all of that was resolved with the preserve owners. Prior to that, they had not paid for any of those assessments. The Buie defendants that owned the remainder of the preserve lots have never contributed to any of that proportionate share maintenance required for the roads or for the the common area.
But they've been using the roads. They can use the roads.
To the extent, yes.
Now, the common
Yes,
area, I've been struggling to find out, is this some sort of boat ramp on the Santa Fe River, or is this?
24 acres. This is if I may, Mr. Buie had 480 acres. He divided it and subdivided it into 43 different lots. He then creates the landing subdivision of lots 1 through 32. This dead ends, the property, a small portion of it, dead ends on the Santa Fe River.
That's
And
the Woodland
That's in
Avenue?
the common area.
Is that Woodland Avenue? You go down Woodland Avenue and it dead ends?
That's correct, Your Honor. So one road in, one road out, but the common area has frontage on the river. There's a boat ramp. That's the purpose of the common area. It is a boat ramp. They have a cabin. It's for recreational use, horse trails and the like. So Mr. Buie, when he creates the subdivision, he sort of is, the king of the castle. As the developer, he creates that and he wants to continue. It's very clear in the record. He seeks to continue that throughout that time. But once you choose to subdivide and you create an owners association and you impose a declaration on this property that runs with the title to the land, well, then you're not king anymore. Suddenly now you have to follow the rules. And under the most important rule here is Florida Statute 720-3075. And this goes back to 2001 when this association was first established, when the declaration was first filed. Only 2 or 3 years prior to that, 720.3075 was substantially amended. And it was amended very clearly to protect homeowners. And one of the things that was done in that amendment, or what was done in that amendment, was that it says you cannot include, and in the appellant's briefs on this case, they totally seek to obscure that. You cannot include, nor can you enforce a provision that says I'm king. And that as long as I want to make amendments to the declaration, I can do it for as long as I like.
We don't have to, I mean, the language of that statute, as I read it, says you can't have anything in your declaration that allows you to unilaterally make changes after turnover.
It
And
says-
so I think the argument might be that implicit in that statute is you can unilaterally make changes and you can have provisions that allow you to unilaterally make changes before turnover. Putting that aside for just a second, we don't have to interpret that statute or get to that if we find that there was evidence to support the trial court's finding that turnover occurred in January, and this amendment was done after that, correct?
That's absolutely correct, Your Honor. That is absolutely correct. I would simply point out, however, that 72307 is the one that's the statute that talks about transition and sets forth requirements of what is to happen in transition. 3075 finds that it's against public policy to have a provision, just as Judge Slaughter found in this case, to have a provision that says, as long as I own at least one lot out there in the landing, whatever I say goes. Any amendment, not only can I amend it myself, but any amendment that anyone else does, I ultimately have veto power over. And that is the language of the declaration that was stricken by Judge Slaughter.
And again, I don't think we need to get to whether that was right or wrong.
I agree with you.
Why, let's assume, for sake of discussion, that turnover had not occurred when this amendment that we're talking about was done, and we do have to look at that statute. Why wouldn't the trial court use too thick of a pen in striking things out? Why shouldn't he have, under the severability clause in the declaration, have construed that to allow unilateral changes before turnover?
Because the statute specifically says that unilateral changes, 3075 specifically says that such clauses, meaning unilateral changes as defined in 3075 1A. 1A is a developer has the unilateral ability and right to make changes to the homeowners association documents after the transition of homeowners association control occurs as set forth in 72307. In this declaration, the transition, according to this Mr. Buie, as long as he owned at least one lot, there was no transition of control. So it violated the provisions of 3075 and 307, and the legislature specifically says such clauses are declared null and void as against public policy. Then it says the public policy described in subsection 1 prohibits the inclusion or enforcement of such clauses.
So your argument would be, even if there was a way to construe the declaration in a manner consistent with the turnover provisions of the statute, the whole clause would go no matter what?
The whole clause, the judge correctly applied the severability clause. He did not entirely strike the entire thing. He simply struck everything that required the developer's approval with respect to any amendments that were done by the board of directors and approved by the membership, or with respect to the unilateral amendment, he found transition had occurred. Going back to Your Honor's prior point, he found transition occurred in January 2003.
Under the statute, which would control over anything inconsistent in the documents, transition had to occur once 90% of the lots were sold. Here, 90% of the lots weren't sold, but I guess your argument is he voluntarily turned it over sooner, which would be consistent with the statute.
It is, and the evidence was very clear that that occurred. Judge Brasington mentioned it, one of the points with respect to that in January 2003, Mr. Buie, he and himself testified, his testimony is in the record, that transition occurred at that meeting where officers and directors were elected. Furthermore, that's when they set the assessments, in the record. Mr. Buie, did your developer board ever set assessments? No, we did not. So it's an admission and an acknowledgement right there that once the 4 members had been elected to the board of directors, that was now a member board. That member board was in control, and that member board set those assessments and went forward and paid and did all of those things. And Mr. Bowie's testimony also talked about the board took off, and they did all of those things.
Let me ask one more question before you turn over the lectern.
Your Honor, yes.
How do you respond to the equitable defenses arguments that were put forward, that even if this occurred after turnover occurred, the agency, or excuse me, the association waived its right to challenge it, or as a stop from challenging it, or how do you respond to those arguments?
Your Honor, that's a red herring with respect to this June 2003 amendment. That amendment says nothing about the right of use of the common area. The moment that things started being recorded about claiming that that meant the right of use of the common area, that first happens in December of 2005. And in January and February of 2006, when the deeds are recorded, when the preserved declaration was recorded. That is the first time there's ever any such language as the right of use for the common area, putting that issue into dispute. And within 18 months, the association filed its lawsuit. And so that would be part of how we deal with it. I also would cite to the Austin Peel letter, I believe it's Exhibit 45, which is when the Buies really discovered what the problem was. That was in November of 2005. That's what started. They went back and tried to rehabilitate the 2003 statute with a filing of another developer amendment long after everyone, including Mr. Buie, recognized that transition had occurred. I'm way over my time, Your Honor, so.
Thank you, counsel.
May it please the court, Jack Bellow for Old Republic. May I also add something on the waiver issue?
Sure.
We have to keep in mind, first of all, assuming that the amendment was void, it did not provide any notice to the board, technically. I mean, I look at this as a situation, I practice in real estate. When you have a mortgage that's invalid for any reason, for example, the attestation is incorrect, it doesn't have the proper acknowledgement, that does not provide any constructive notice or knowledge to an individual looking at the public records. It's just it's a legal technicality. The other thing is we have to keep in mind, who is the protected class? They're trying to argue that the member board, and they're saying member board in their brief, okay, so we have to assume that the members control the board at that point in time, that somehow a member board waives certain rights by not doing something. Well, whose rights are really at stake here? It's the rights of the homeowners of Bluebird Landing, not the rights of the directors. Directors cannot waive the rights of the individual owners who, under the declaration, once the amendment, I should say, once Article or Section 8A was determined to be null and void, that you look at the remainder of the declaration, and it provides that you have to have a quorum, you have to have 60% approval on the amendment, you have to have the president sign it, and it has to be certified by the secretary. All those rights belong to the owners. They have the right to amend the declaration. So in regard to waiver, I'll put that out for the court to also consider. If I also may comment on severability, that was raised with the assumption by the appellants that the Section 8A was stricken by the court's summary judgment order. The way they argued it in the brief was they cited 3 cases. In all those cases, none of them had a severability provision, by the way. Those cases dealt with severability based on a situation where a provision was deemed to be unconstitutional or illegal, and the court had to answer the question whether or not the entire agreement was invalid. Okay, so we have a much different situation here. Applying severability in this case, it knocks out the invalid provisions of Section 8A and a part of Section 8B.
Well, I guess my question, again, I don't know if it really matters ultimately in this case, but why did the trial court need to strike the entire provision if the statute seems to allow unilateral amendments by developers while they're in control of the association? So at least insofar as that aspect of that provision, it would seem to not be invalid.
Well, I've been sitting here, I disagree with that statement with all due respect to the court, because some of the words that they focus on, the appellants, they focused on enforcement, and they left out some really important words in the statute, including the effect of. And that's what I think the court looked at when, based on the conclusions of law. When, if you read the statute, it says, it is declared that the public policy of this state prohibits the inclusion or enforcement of certain types of clauses in homeowners association documents, including declaration of covenants, articles of incorporation, bylaws, or any other document of the association which
But I
binds
guess
members.
my point is this, and the inclusion is very interesting because it's more than enforcement, but under a literal interpretation, the argument you're making, if a developer has in it a provision that says, I can make unilateral changes to this document forever, which clearly is inconsistent with the statute, simply by including that in there, it would need to be stricken, and then I guess the developer couldn't make unilateral changes even before transition. That makes no sense to me.
Well, if the section is invalid, they should have some other provision in there that would allow certain things to
I
happen
think
under
the
those
severability
circumstances.
clause makes sure that something is, at least as I understand them, that you only excise out the part that's invalid and everything else stays. But again, I think we're arguing about something that if you're right, or if this side of the room is right, that there was evidence to support the fact that turnover occurred in January, it really doesn't matter because no one's arguing that an amendment can be unilaterally made after turnover.
Right, and that's our position also, and the most competent substantial evidence is the words of the developer himself when he said he turned it over at that meeting in January of 2003. It took off, assessments were charged in, Judge Brazelton mentioned that, and that's our position. If there's no other questions, I thank you.
Thank you, Counsel.
Yes, the statute says that members of the developer are entitled to elect at least a majority of the members of the board of directors at the earlier of the following events, and subsection A of that is 3 months after 90% of the parcels in all phases of the community they have been conveyed. This did not occur in this community until well after the development. The common area amendment was recorded, number one. Number
Let
two.
me ask you about that point, though. That statutory language seems to me creates an absolute end, drop dead date,
Yes.
but it doesn't, or does it, maybe is a way to present it, does it preclude a developer from turning over sooner?
It does not necessarily, but to suggest that a developer could turn over when even less than half the lots were sold turns a lot of homeowners association law on its head, because at least at the time of January of 2003, only 47% of the lots have been sold, so they weren't even at a 50% level, number one. What's concerning is the statute says directors, and yet we have a bunch of folks running around saying, well, maybe I'm a director, maybe I'm an officer. They shouldn't be able to define their role by saying that we thought directors were selected. That's not what occurred.
Their argument is that Mr. Buie gave them that label.
Mr. Buie also, if you look at the minutes of January 13th and beyond there, all talk about officers, never say anything about selection of directors. They're always defined as officers, number one. There's nothing that is prohibited by the statute for a developer like Mr. Buie letting a group of officers make decisions about things before it's turnover. And we would suggest that the turnover is when, at least by 2004, the state is informed there has been the selection. I would also remind the court that this case has been here before. It has been here before on construction of the common area amendment, because Judge Collins had the case earlier, and he entered summary judgment on both of these folks' behalf, finding that the common area amendment was not sufficient to permit, the common area amendment was to commit use of the common parcel. And what the amendment said was, it said it was an easement and right of ingress and egress. And this court agreed with our position that the conjunctive, easement and right of ingress and egress, both conditions had to apply. You didn't agree with our position that easement in plot was right of use. And so you sent it back for there to be a determination of the intent of the parties. The intent of the parties, the only evidence adduced at trial was the evidence of Mr. Buie's. Mr. Buie passed away several years ago before trial. But his testimony and his deposition and an affidavit where his intention was the use of the common area to be shared. So
we only get to that if we get to the point of determining the amendment was valid, correct? Correct?
yes, yes. Mr. Bello suggests that the amendment did not provide constructive notice. There is actual notice of that amendment. One of the, I think the secretary of the association, and I don't have the record reference right in front of me, testified in her testimony at trial that she was aware of the common area amendment.
How do you respond to his argument that whatever actions or inactions the board took were insufficient to waive rights that belong to the individual homeowners?
Well, waiver can be direct or implied by conduct. And once the common area amendment was known to the board, actually it was approved by the board prior to the time it was enacted. It was recorded. It was approved by the board, and then after the fact, when lots were sold to the preserve owners, there's notes in some of the record, the minutes, of an acknowledgement and a recognition that the owners of the new lots would have right to, and I think they say roads and park. So they had accepted that that was correct the whole time.
They being who?
The landing association folks. And it wasn't until way after the fact, it wasn't until people started fighting about how much to pay for use of the common roads that this all blew up. But if you look at the minutes, and there are a number of their individual plaintiffs' exhibits, there's one lengthy defendant's exhibit that has all the minutes. The minutes are very clear that they call themselves officers and they didn't object. So, thank you very much.
Thank you, counsel. All right, that is the last case on our docket today, so we will be in recess until docket tomorrow. Thank you.
All right.